As the dust settles on the introduction to the Children's Wellbeing and Schools Act 2026, I am taking a review of this landmark legislation that received royal assent on 29 April 2026, and I am comparing it with the Children's Act 1989. We need to remind ourselves that we've got to embrace the realities of the changes introduced by the Act and incorporate them into our various practice as social workers, caseworkers, or advocates. This Children's Wellbeing and Schools Act 2026 has implemented sweeping structural reforms spanning education, child protection, and online safety. We now need to keep in mind the key amendments at every stage of child protection. We are going to consider the key changes to the practice or our practices in this video. A central objective of the 2026 Act is modernizing, tightening, and reframing specific provisions of the foundational Children Act 1989. It shifts local authority duties towards family preservation, multi-agency visibility, and structured statutory framework. Before I delve into the detail of the changes, I will now do a quick summary of these changes. That is the summary of amendments to the Children Act 1989. Dealing with the first one, Section 31, the provision amended in the Children Act 1989, Section 31, which deals with care orders and pre-proceedings. The core mechanism of the 2026 amendment in relation to this is that it mandates a family group decision-making, otherwise known as FGDM Meeting, before filing the application. The primary strategic objective for this is to give priority of kinship care over state intervention. The number 2 amendment provision is Section 25, which deals with secure accommodation. The core mechanism of the 2026 amendment is that it restructures the framework to authorize deprivation of liberty, otherwise known as DOLS. And the primary strategic objective is that it regulates alternative therapeutic settings. The third provision amended under the Children's Act is Section 22, subsection 3A, which deals with duties to looked after children, otherwise known as LAC. The core mechanism of the 2026 amendment is that it inserts an explicit duty to promote whole and or step-sibling contact. And the primary strategic objective is that it preserves family bonds while in care. We'll now turn to the next amended provision under the Children Act 1989, which is Section 23C and 24, which deals with care leavers. The core mechanism of the 2026 amendment is that it places staying close schemes as on a mandatory statutory footing, and the primary strategic objective is that it eradicates regional post-care support disparities. The next amendment to the 1989 Act is Section 17 on Part 3, under Part 3, safeguarding partners. And the core mechanism of the 2026 amendment in this regard is that it mandates multi-agency child protection teams and education partners. The primary strategic objective in this regard is that it eliminates information silos with a unique ID. I now turn to each of those key amendments in a little bit more detail. Now, let's look at Section 31, dealing with pre-care proceedings and family group decision making, otherwise known as FGDM. The 2026 Act introduces an explicit statutory obligation forcing local authorities to arrange and facilitate a family group decision-making meeting before they can apply for a care or supervision order under Section 31, subject to defined emergency exceptions. This is a monumental shift towards statutory family preservation. Previously, involving wider kinship networks was heavily encouraged in guidance but lacked statutory teeth. By embedding FGDM as a legal prerequisite, the state attempts to exhaust kinship care options before taking a child into care. However, the critical bottlenecks will be resource allocation. Local authorities face severe financial strain. Forcing mandatory meetings without ring-fence funding may cause systemic delays in legal planning, potentially keeping children in unstable environments longer while meetings with relevant wider family are being arranged. We now turn to the Second Amendment under Section 25, which deals with restructuring deprivation of liberty DOLS framework. I'm going to assume here that my listeners understand the ramification of Section 25. So I will not go into the detail of Section 25 Children Act. Suffice it to say, the amendment, it fundamentally revises the secure accommodation framework under Section 25 of the Children Act 1989. It creates a formal statutory mechanism to authorize the deprivation of liberty of children with complex needs in alternative, highly restrictive, therapeutic or medical care settings, rather than restricting DOL strictly to the traditional secure children's homes. This amendment addresses a severe, long-standing crisis in children's social care. For years, a lack of secure children's home places has forced local authority to use the High Court's inherent jurisdiction to place children in unregulated, non-statutory, restrictive settings. Bringing DOL cases under a statutory framework provides these highly vulnerable children with mandatory review points, legal representation, and strict regulatory oversight. Critically, while it legalizes and structures a wider array of placements, it risks normalizing the deprivation of liberty if robust inspection regimes do not stringently police these alternative settings. We now turn to the next amendment, that's section 22, subsection 3A, strengthened rights to sibling contact. The Act amends section 22, subsection 3A, which dictates the general duties of local authorities towards looked after children, by inserting a specific statutory duty requiring local authorities to promote and maintain reasonable contact between looked after children and their whole, half, and step siblings, provided it aligns with the child's welfare. Historically, children in care have frequently been separated from siblings due to a lack of large foster placements or fragmented local authority tracking, resulting in profound emotional trauma. Elevating sibling contact from a guiding policy principle to an explicit, actionable statutory duty allows children or their advocates to legally hold local authorities accountable. The practical obstacle is the national shortage of foster carers and appropriate care planning. A statutory duty does not automatically create physical infrastructure or larger homes to keep sibling group physically co-located. We now turn to number 4, which deals with section 23C and 24 of Children Act as amended, statutory staying close support for care leavers. The 2026 Act updates care leavers provision within the Children Act 1989 framework by placing the Staying Close program on a mandatory statutory footing. These legally binds the local authorities to provide structured, tailored institutional support and transition funding for young people leaving residential care to move into independent living. Moving Staying Close from a patchily funded pilot program to a universal statutory right eliminates a harmful postcode lottery for care leavers. The cliff edge transition from institutional care to total independence at age 18 has historically driven high rates of homelessness and unemployment among care leavers. While the amendment provides a vital safety net, its long-term viability hinges entirely on whether the government backs the statutory duty with continuous central funding or if it becomes an unfunded burden on local government budgets. We now turn to the Fifth Amendment under the Children Act 1989, which is Part 3 and Safeguarding Arrangement, Multi-Agency Protection, and Unique Identifiers. While intersecting with education law, the 2026 Act amends the operational framework of safeguarding partners under the Children Act 1989 by mandating the creation of statutory multi-agency child protection teams. It embeds education settings as formal relevant partners in local safeguarding duties and introduces a single unique child identifier across health, education, and social care databases. For decades, serious case reviews have consistently cited information silos and communication failures between schools and social services as primary factors in child protection tragedies. Forcing schools into the core statutory safeguarding apparatus and deploying a single unique identifier drastically reduces the chances of vulnerable children falling through the cracks. Conversely, civil liberty groups have flagged data privacy risk regarding the unique identifier, noting that personal information could be overshared across agencies without explicit consent unless strict safeguarding firewalls are maintained. I would say, in conclusion, the 2026 legislation, that is the Children's Wellbeing and School Act 2026 legislation, is an extremely valuable legislation and really welcomed. It fundamentally shifts the philosophy of the Children Act 1989 as we knew it. While Children Act 1989 originally sought a delicate balance between family autonomy and state intervention, the 2026 amendments construct a significantly more interventionist, coordinated, and highly visible state apparatus, which is quite needed. By legalizing alternative form of liberty restriction and mandating state-led multi-agency tracking, the 2026 reform heavily enhanced child's visibility. However, the success of these amendments relies on addressing the severe staffing and financial shortages affecting local authorities' children's service. Please let me know your thoughts and views and comments to this video in the comments below. And please click share with your friends and subscribe to this channel if you've not already done so. I look forward to seeing you or meeting you in my next video.